Well, as laws surrounding estate planning continue to change over time, law experts advise dusting off existing wills and trusts to make sure they'll still function as intended at the time of death. Joining us now is Roger McEowen. He's with the Washburn University School of Law. Roger, as always, thanks for providing us some insight today. First of all, just exactly what should we look for whenever we need to modify things?
Yeah, that's a good question. Good to be with you, Janet. I think there are at least 4 key, maybe 5 key things that need to be examined routinely every couple of years. Of course, your goals and objectives might change. And of course, the longer the time frame you have between the times that you have looked at an existing plan, the more likely it is that your goals and objectives have actually changed. Maybe you've acquired new property. How is that incorporated into your estate plan? You need to update to factor that in. Has your family structure changed? I think that's another one. Do you own more property or additional property by what we call beneficiary designation? Are your beneficiaries listed properly in the way that you want them to be in terms of who's going to get your property once you're gone? And then, of course, if you have an existing will or a trust, is your language that specifies out how the property is to pass correct? Is that clause language update to reflect current law?
Roger, common will, common trust language, is that an issue to be concerned about as well? Does that change over time?
Yeah, that's a big issue because the law changes. The underlying law changes. The federal estate tax exemption now is much higher than it used to be a number of years ago. And a lot of times drafters will use language that will tie into that existing credit level. If that's the case, then you might have a plan that's now out of balance and not leaving the property in the way that you want it to be left. So that needs to be taken a look at.
And what is the formula clause language, and what all does it exactly do?
That's the language that ties to the federal exemption that splits out, for example, an outright share to a surviving spouse with the balance perhaps going to the spouse in what we call life estate form with the remainder to the kids. If that gets out of balance because the exemption now is higher than at the time that clause language was created, you may now have totally overfunded one of those shares or defunded one of those shares, and that may not be what you want to have occurred.
Roger, do you have an example?
Yeah, let's say we've got a married couple and they have combined spousal wealth of $3 million back in 2001 at the time when the federal estate tax exclusion was $1 million. So they retitled their assets, they balanced the value of the assets between themselves, and if you have, for example, the husband dying first, we get a taxable estate of about $1.5 million. Well, the clause would cause $1 million to pass to what we call the bypass trust with the balance going to mom outright. There's no federal estate tax. Now you factor in that the estate tax exemption is $11.4 million per person. That language is totally out of whack. That's got to be taken a look at.
All right, Roger, as always, thank you very much for your insight today. Again, Roger McEowen, he's with the Washburn University School of Law, joining us on the phone today from Topeka, Kansas.